Welcome to Counselor, Beyond Conventional Defense.
Hello and welcome to Counselor, Beyond Conventional Defense, the podcast that challenges the traditional approach to criminal defense and takes a deeper look at how the justice system can evolve. My guest, as always, is attorney William Pernik, a trailblazer in criminal defense whose approach is anything but conventional. I am your host, Kevin Rosenquist. Today's episode is Beyond the Breathalyzer, a holistic approach to defending DUI cases. William, welcome back.
Thank you, Kevin. It's a pleasure to be here.
DUI charges in California can come with some serious consequences. Can you walk us through the potential penalties a person might face if convicted of a DUI?
Absolutely. In California, there is a system of graduated punishment. So the more prior convictions for a DUI you have, the greater is the punishment you face. And depending on your prior record and the facts and circumstances of your current DUI, you could actually be looking at a punishment of up to a life in prison. First offense DUI carries a minimum sentence of 48 hours in custody, a maximum sentence of 6 months. The penalty increases fivefold from the first DUI to a second, so the minimum sentence becomes 10 days, the maximum sentence a year. If you commit a third DUI, the minimum sentence is actually 120, so it is significantly amplified. And the fourth DUI within 10 years, there's a 10-year washout period, but a fourth DUI within 10 years is a felony that can carry up to 3 years, assuming you're very, very lucky and nobody got injured. Where people look at catastrophic exposure in terms of their sentencing is if, God forbid, there was an accident of some kind and there was an injury. Having 3 or more prior convictions in 10 years or being involved in a DUI that causes an injury to someone else are the two things that can make your DUI from a misdemeanor a felony. And if you have a prior felony DUI, that could also make it a felony. So if you have a DUI causing injury, depending on the injury that you have and how many people are injured, you could potentially get up to 3 years additional and consecutive punishment for every great bodily injury that a person has. So if you, God forbid, struck a car with 4 passengers in them and 3 of them have great bodily injuries, you're now looking at a 12-year sentence. If you have 2 or more prior serious or violent felonies, you could be looking at a life sentence. And so DUIs are cases where a lot of people assume they're easy cases to handle, easy cases to plea bargain. They don't really pay attention to the underlying problems people have. And when underlying issues that lead to persons' unhealthy relationship with alcohol or drugs and driving are not resolved, it could lead to further DUIs and it could lead to somebody dying or getting really seriously injured. So what I always like to tell clients who I meet on the DUI charges that, look, at this point, you're very, very lucky. Assuming I'm dealing with a first or second or third DUI, I'm not dealing with a DUI where somebody got injured. I said, look, at this point, you're very, very lucky because you have not done anything yet that can be taken back. But if, God forbid, you're involved in a kind of case that I sometimes get calls on, and you have maimed a person, you have caused a person a permanent or a very serious long-term injury or disability, or if, God forbid, somebody died, you're going to have to live with that forever. So let's take a look and see, why did this happen? How did this come about, so that we can make sure this never happens again. And obviously, as the person is going through the treatment process, as the person understands and connects with what it is in their background that caused them to do this, and as we earn credibility with the court and with opposing counsel by demonstrating commitment to treatment and sobriety, that's when you see legal outcomes improve tremendously.
Now, there's sometimes where you'll use a conventional and sometimes an unconventional approach to DUI cases, correct?
Yes.
What is the thought process on how to decide which one is best?
I think to truly understand and appreciate it, I would have to walk you and our audience through what it looks like to defend the DUI conventional, and I can give some real life case examples, and what it looks like when you go beyond the conventional defense, if you don't mind.
That sounds great.
Okay.
I like examples. It helps me understand.
Okay, my pleasure. I have lots of them. 20 years
sounds like it.
examples. Okay. So it's dangerous to ask me to provide one. You might end up with 27. So look, in a DUI case, using conventional approach, we basically would do some of the things that are similar to what we do on many other criminal cases. You examine the evidence that the government has against your client. You determine, how can I attack any of these critical pieces of evidence? Okay, so in the DUI case, you will look, number one, to see what is the reason for the stop. If police officers do not have a legal reason to stop you, then anything they discover as a result of an illegal or unlawful stop can be challenged and excluded from evidence. If it's excluded from evidence, government cannot use it, so they may end up with a case they can't prove without evidence that was obtained unlawfully, so that could be a win. Outside of the reason for the stop, you look at all of the factors police officers rely upon in their DUI investigation. What is the driving pattern of an individual? What is the drinking history for an individual? What is the person's performance on field sobriety tests? Was there an accident of any kind? What were the results on a person's chemical test if they were given a breathalyzer? How high or how low was this person's breath alcohol? If a blood draw was conducted, what are the blood results? Are we dealing only with alcohol, or are there controlled substances in a person's system? If so, are these substances psychoactive? How do they affect the person's central nervous system? Do they impair one's driving? And so all of these things deal with the law and with the facts. And in cases involving the most serious of DUIs, we also have an added element of causation, which is whether or not a person's driving under the influence of alcohol actually caused somebody else to get injured, oftentimes to sustain a serious or great bodily injury. And in those cases, you deal with accident reconstruction, you hire experts, or you cross-examine aggressively experts that are testifying against you and your client on the other side. And those are very, very serious types of arguments that you have to be really well prepared for, and they're the right arguments to make in the right case. I started my career as a trial lawyer in a rural county of Tulare, and my very first felony case, and case that really put me on the map, was the guy who gets extraordinary results, was a felony DUI case with multiple great bodily injuries and a life exposure. It was a case that was handled by a senior attorney in the firm. It was reassigned to me for training purposes in order to teach me how to do felony sentencing. Okay, I was very lucky to have a friend of mine who was an older attorney. He's no longer with us. His name was Dave, and so Dave was assigned to make sure I don't screw things up royally as I take this case to trial and don't get myself held in contempt with this really, really strict felony judge, because I just came out of misdemeanor courts. I've done like 15 or 16 jury trials in the first 6 months I was a public defender. And now they're giving me this super serious case where we're dealing with 4 violent felonies alleged, one for each person that was injured, and a client who had a very serious prior criminal record. This client was a Native American gentleman. He lived on the reservation. He was driving very, very intoxicated, was almost 3 to 4 times the legal limit in California, which is 0.08. So he had well over 0.20 in his system. And he was involved in a collision driving up to a reservation, which had a casino on it. And so from that casino, there was a car traveling down the mountain on this really treacherous, extremely poorly maintained road that had potholes, that had multiple accidents on it. So you have somebody who's really intoxicated going up the mountain, and you have a car filled with young adults, with kids, as I called them, who were coming back from the casino. And there was a collision, there was a crash, and the kids got horribly injured. One of them needed brain surgery. Somebody needed to be airlifted. And then my client, years before this, and my client was an alcoholic, my client, years before this, was involved in a shootout with a number of police officers and apparently had 8 or 9 prior strike convictions. Okay, it was a long time ago in his past, but nonetheless, because of those prior convictions and the fact that he was being charged with these crimes now, he was looking at a life sentence, and the offer going into it was 20 years. So I was just promoted to doing felonies, and they wanted me to learn how to do felony sentencing by handling this case. The expectation was that my client, of course, was going to be convicted and, of course, was going to be sentenced. And it would be really good for William to learn how to do one of these on a case that was labeled a quote unquote DBL, okay, dang bang loser. Okay. So going into this case, I was super scared. I did not want my very first felony trial to end up in a conviction and a life sentence. It would have been horrible for the very first felony client I have to end up with a life sentence. Okay. Right. And the 20-year offer was a no-go for my client because he has served a lengthy term in prison. He didn't want to go back there, and he wasn't prepared to do it. So we started investigating this case very, very aggressively, preparing very aggressively. And my late friend was instrumental in keeping me leveled and keeping me focused. And so I prepped. I brought legal challenges to attack some pieces of evidence that were obtained. In particular, there was a video simulation that was very, very powerful, and it presented was a computer graphic, even though it was a long time ago, in a very believable manner how the accident happened. But some of the underlying assumptions for that simulation were wrong. Some of them were not produced to us on time. So we brought a legal challenge and were able to get the judge to exclude it. So that was one damning piece of evidence that was excluded. We attacked causation of this accident. As it happened, the CHP officers who investigated the accident lost the photographs that they took of the crime scene. So we had their initial drawings and diagrams, which were relied upon by the government accident reconstruction expert, but the underlying facts we couldn't present to the jury anymore because the CHP didn't do their job and they lost photos, okay? Which was a really stupid and incompetent thing to do.
Yeah, seriously.
So we examined the damage to our client's vehicle, and we saw that not only was there front end damage, but there was also damage to his rear bumper, which was consistent with our theory of defense, which was that our client, drunk as he was, could drive that road, which he drove every single day, better drunk than these kids probably drove sober. And our theory of the defense was that they caused the accident. They're the ones who clipped him, causing him to hit some rocks. And when you look at the damage on the back of his car, there was in fact damage. I had a really wonderful investigator at the time who was a very charismatic Hispanic woman. And she contacted, at my request, I directed her to contact every single person who called the police who was driving past this accident. And we got these 911 callers in court. They testified to the resting points of the vehicles, and they were different from what the police officers documented. And since they didn't have photographs, it allowed us to challenge the underlying assumptions that the government accident reconstruction is made. So we attacked the causation element, and without causation, the government couldn't prove a felony DUI. The kids lied about what happened. They had some criminal backgrounds. We impeached them with that. There was very aggressive cross-examination, and we were successful in challenging their credibility. And then at the end, we also tried to argue that our client wasn't even potentially at the blood alcohol or breath alcohol level that he was, because due to his injuries, the officers didn't stick the breathalyzer in his mouth and had him produce a deep lung sample. But instead, what they did is they used the manual trap mode, which is a lot less reliable. It kind of works almost like a vacuum cleaner, sucking up ambient air coming from your mouth and nostrils. Very different from you really inhaling and exhaling and providing a deep lung sample. So we argued that the BAC wasn't what it was, that the causation was backwards, and they struck our client's car. We argued credibility. We argued incompetence. And at the end of the day, the jury acquitted our client. The jury found him not guilty and of the felony DUI because they really didn't believe the government met their burden of proving beyond a reasonable doubt. They had a reasonable doubt, Kevin, about whether or not he actually caused the accident. They did think he committed a regular DUI, but for him, having spent so much time in pretrial custody, looking at a life sentence, maximum sentence on the DUI, first offense was 6 months. A repeat offense DUI would carry a year. He had credit time served. And one of the things that were most incredible that happened was my client and I had a series of personal conversations. And one of the things that I like to do with my clients when I feel that they need to, lay their soul bare when they're being judged by the jury is I always ask a client when I identify kind of like what's the reason why this happened. I always tell them, look, man, if God willing, you have a chance and the jury finds you not guilty, will you please promise me that you will never do this again? And this gentleman was committed that if ever given a chance again, he was going to stop drinking and he was just going to race horses at the reservation. That's exactly what he did. And so that was the first very serious felony trial I had. It resulted in me being assigned the most complex cases that nobody else thought, had a chance of winning. And so it allowed me to cut my teeth on a DUI case and learn from it. And that was my early exposure to that. But over the years, I realized that that's not sufficient for so many of my other clients, and something more needed to be done.
Mm-hmm.
So if you want, I can give you some examples of where something more needed to be done.
Yeah, I'd love to finish out with a comparison. What's a good comparison to the conventional approach
Sure.
where you used an unconventional.
So I'll give you an example, for example, of a police officer client, another police officer client that I had who was prior service. He served in the military. He developed some mental health conditions as a result of his service in the military and exposure to some of the traumatic events. Okay, so he had these underlying mental health issues. He's in a very stressful line of work as a police officer, and it led to an unhealthy relationship with alcohol, which again is not uncommon. We're going up against this double standard that a lot of our law enforcement clients experience, and I've discussed that in our prior episode, where a police officer is going to be treated way harsher in a pending criminal case than an average person, despite the public perception from some high-profile cases that cops get off scot-free. That's not the case actually for majority of these cases that I'm, handling. And so my client was looking at a DUI. It was a legitimate DUI because there was a legitimate stop. We examined the case for forensic issues, such as issues related to alcohol absorption, whether or not he had rising blood alcohol, whether or not the machines were working or not working, etc. But none of that was going to lead to the right outcome, which is avoiding a conviction. But because of his prior service in the military, because of the psychological conditions that he had, we realized there was a better way. We had him evaluated by a psychologist. We had him qualified for treatment through, I believe, the Veterans Affairs. And he swallowed some, bitter pill, and he had to go through the same program that a lot of other folks did. But he came out so much stronger and so much better on the other end of it that not only did he get healthier and stronger, he got his criminal case dismissed. And that was incredibly powerful. I'll give you another example. I had a woman I represented several years ago who I never forgot. This woman who, for her protection, I'm going to call her Gina. That's not her real name. But Gina called me on a second DUI. Just like the case with this police officer, it was a case where conventional approach couldn't really do very much for her. Police officers had probable cause to contact her. Police officers observed signs of intoxication. They conducted appropriate evaluation. Investigation was such that we couldn't challenge, and she was looking at a DUI conviction. But despite all of the challenges that the case presented, in talking to her, I immediately realized that given the issues she had, was a very toxic job, was a very toxic boss, given problems that she had in her relationship, given her past history, she obviously suffered from an underlying mental health condition. Okay, so I told her at the conclusion of the call that, look, I understand you have this legal problem, but I got to be frank with you, Gina. I think that you have much bigger problems than your case. And whether you hire me or not, here's what I think you need to do in order to fix the things that are happening in your life. At that time, she had almost no money. She had a job she hated. She just got involved in a DUI, couldn't get back on the road legally, was looking at a license suspension, all of these issues. But she called me back and she took it to heart, and she actually invested in self-care. She hired a wonderful therapist who I refer a lot of my clients to. She really engaged in treatment. And she's done so well in treatment that we actually persuaded the court to grant her diversion. At that time, you could still get diversion for a regular DUI. Today, you could get diversion if you're a member of special population, like a veteran, but you could not get diversion on most DUI cases because of a provision in a vehicle code that forbids it. And so at the time, there was a diversion statute that allowed it. And so Gina went through diversion, and she did so well. She started to thrive in her personal life. She started to understand healthy boundaries in her working relationship. She did better in life. She did better at her job. And she learned how to handle challenges. And right when she was about to finish everything and have the case dismissed, a horrible thing happened. And the horrible thing that happened is that the district attorney in her case, who did not like the fact that she was granted diversion, apparently had pursued an appeal. And the law has changed in the meantime. And so this woman was denied the benefit of a program she has participated in for all this time. But thanks to the counseling she received, thanks to the therapy she received, thanks to the strength of the bond that me and her had, because we went through this journey together for a long time, she not only stayed in treatment while the appeal was pending, but we were able to come back and we were able to get her a really great outcome that did not cause her to lose her license again, because by then she got her license back. We obtained a plea to a much lower charge, and we had the judge essentially give her an opportunity to not be on probation anymore. And then we came back. with a request to dismiss or expunge her record, and it was granted. So
Wow.
even though she ultimately lost the benefit of the program she all but completed, at the end of the day, she got an outcome she would have never received on the second DUI in the state of California. She didn't have to do 5 years probation. She didn't have to spend thousands of dollars in fines and fees. She didn't lose her license again, and she changed her life. And she sent me a very special gift that I have on my bookshelf to remind me of her and to remember her by.
That's really cool. That's a really cool story. It's nice to hear that when that stuff works, especially even when it was almost didn't work due to the DA trying to take that away. But that's awesome. Well done, sir. Well done.
Thank you, Kevin.
All right. Well, thanks for tuning in to Counselor Beyond Conventional Defense with attorney William Pernik. To connect with William and his team, head to perniklaw.com. And of course, don't forget to like and subscribe to our channel. We love having you here. William, always great chatting with you. Thanks so much for the insight. Thanks so much for the stories. Really appreciate your time.
It's my pleasure, Kevin. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.